One of 7 seats on the Wisconsin Supreme Court will be filled in the April 7 election. The 2 candidates are veteran Rock County Circuit Court Judge James P. Daley, who joins us today, and incumbent Justice Ann Walsh Bradley, who is seeking a third 10-year term on the court. Your Honor, Judge, welcome to Wisconsin Eye.
Thank you for having me.
You know, I looked it up, and the 2013 election for the Supreme Court Justice, only 17% of the voters participated. It's a low turnout election. So let me ask you this. What's at stake on April 7th in terms of your race, Your Honor?
For me, it's a clear choice for the voters of Wisconsin. My opponent is a judicial activist, and I'm not. And
what does that mean?
To me, that means...
Help me understand
sure,
activist.
Sure. And it's a question a lot of people ask me.
Yeah.
Interestingly enough. Judicial activism is one, well, I'm not an activist. I believe that the Constitution, the rule of law, must be placed above individual beliefs, personal agendas, or partisan political goals. Activists turn that on its head. Mm-hmm. They say they, in fact, are elected to make those decisions. If they believe the legislature has made a error in policy decision, mm-hmm. then in fact they're there to correct it. I believe that the Constitution gives the legislature certain constitutional authorities, including setting policy through statutes. We only get involved in the circuit courts, or at least in the Supreme Court, if in fact they cross the line and it violates the Constitution. And we shouldn't be changing the test of what violates the Constitution just to be able to find something unconstitutional.
Do you think Judge Bradley has been an activist on the Act 10 case and photo ID, and going back as far as 1995 on the lead paint decision, Your Honor?
Yeah, the lead paint decision, Thompson versus Mallet, was 2004-2005 session.
Oh, okay. I was a decade off. Excuse me. Thanks for the correction.
And yes, that is activism. That, as much as Herndon versus Patient Compensation Panel, which was the same session, those decisions, on the one hand, the Herndon versus Patient Compensation Panel rewarded one group of folks, which are consistent donators to Justice Bradley's campaigns, which have been the trial lawyers. Mm-hmm. And the other, the Thomas versus Mallet, or the lead paint decision, that again, throughout several hundred years of established law, be able to find a Wisconsin corporation liable for an injury they couldn't be proved to have caused. This resulted in a lot of Wisconsin workers losing their jobs, and in fact rewarded, surprisingly, trial lawyers. There's another trial lawyer decision. Act 10, since the legislature created the right for unions to organize in public government, they can take it away. It's as simple as that. I mean, I understand it was an issue, it's a hardly fought political issue, but when it comes to the Supreme Court, again, like I said, we determine whether it's constitutional or not. And that's a pretty high test. And in fact, they did find this one constitutional, but Justice Bradley voted with the dissent.
What about the photo ID, just in case, Your Honor?
Photo ID, I think many states have photo ID. It's not unusual to ensure that we have a electoral system process which is free from fraud or abuse, and it's one way of ensuring that, taking the question right off the table. And it's a good thing as long as everyone can get photo IDs, and easily get photo IDs, and without cost for people who cannot afford them.
One of the things, having covered a few Supreme Court races, one of the things that's frustrating is candidates haven't taken positions. So I'm kind of glad that you're taking actual positions where voters can judge you. But by doing so, let's just talk Act 10. Will you have to get off any future cases involving public employee unions because of what you just said on Act 10, Judge?
No, it depends on what the legislature does. I mean, if the legislature decides to do something which is clearly unconstitutional and beyond the authority of the legislature to do, I will find it. I will find it so, but I will use the test of the rule of law and the Constitution. I will not use my personal beliefs. I will not use my personal political opinions. I will not use any hidden agendas. I think the rule of law is too important to be used, to be forgotten in favor of activism.
Since you've taken positions, there was a lawsuit filed in federal court on the right to work law last week. Do you have a position on that? There's nothing pending in state courts. Any position, Your Honor? I
have not, frankly, reviewed. I've been campaigning, so I really don't know, frankly, other than it was passed. I knew that.
Okay.
I don't know what the law looks like.
So you don't have a position on it?
Not yet. I don't.
The ad that I hear on Milwaukee radio stations says that Justice Bradley has accepted money from out-of-state radical groups. Which groups, sir?
She's accepted money from. It's a good question. I haven't heard that ad.
Okay, you haven't? I
haven't heard that ad.
Okay.
She's accepted money from trial lawyers. She's accepted money from WEAC and other unions.
Okay.
I know that. I'm not quite sure what the out-of-state money she's received. I certainly have not received any out-of-state organizational money.
Okay.
I think I received 2 state donations. My daughter tells me one is from Kentucky for $100. One was from Texas for $400 from individuals. So other than that, those are my only out-of-state campaign donation.
The same radio ad says Justice Bradley has voted against the Second Amendment rights. How many times and which cases are you talking about?
State versus Fisher, 2007. Okay. That's one of the precursor cases to the push to get the right to carry in the state of Wisconsin. She ruled in that case that, in fact, it did not harm the Second Amendment rights to refuse to permit weapons in vehicles.
Okay.
And that was really one of the driving forces that got the legislature to create the right to concealed carry in the state.
Having covered a few political state conventions, I've noticed sometimes justices go. Would you show up at the Republican Party state convention? I ask in terms of Republicans because your campaign has been helped by some type of aid.
Well,
is it proper?
It may be proper to visit as a visitor, but not as a delegate, and certainly not as a participant. I can see, in fact, I wouldn't mind going as a visitor to the Democratic state convention. The only problem with it is they really double or triple the cost to stand way in the back of the room as a visitor. But that had come out of my own pocket. But I don't see that's a problem if you go as a visitor, but if you go as a participant, no, that's not appropriate.
You're seeking a nonpartisan office, but are you the Republican candidate and is she the Democratic candidate? I mean, is the term nonpartisan kind of meaningless now, Judge?
I don't think so. Justice Bradley is an activist judge, and that means she has a natural, I think, following in a certain part of the electorate. I'm a conservative jurist, and that's a natural following on one part of the electorate. But I got to point out that I've got Democratic sheriffs who support my candidacy. They see this as, frankly, a law enforcement issue, not a Democratic-Republican issue. It is a law enforcement issue.
Supreme Court justices now have to offer no explanation when they withdraw from cases. Would you give specific reasons why you'd be stepping off a case if you're elected, Your Honor?
I believe that the rule is that you have to recuse yourself. Well, the rule is, just as the circuit court level, the rule is if you cannot be impartial or cannot be fair to one of the litigants, you must remove yourself from the case. And that is something which I know every judge takes very seriously. And I would recuse myself from those cases in which I had a personal interest or even appearance of impropriety.
Would you offer reasons for doing so?
If asked, I suppose I would. The fact of the matter is, I'm one of those old school guys. I like the test of appearance of impropriety or the appearance of not being able to be instead of an actual. I think the term is an actual, but I think the appearance is enough. I think the justice should or a judge should recuse himself if there is an appearance that you might not be be able to be fair to both sides or impartial.
Do you think getting contributions, campaign contributions of X size, 10,000, 20,000, would be grounds in and of itself to withdraw from a case, Your Honor?
20,000 probably would be, since that's illegal.
Okay, you're right. You're seeking a statewide office, right, and the cap is 10,000.
10,000,
so,
right.
Thank you again for correcting me.
Well, and I don't mean to, but the question was whether or not I would.
Right.
I would not accept $20,000 from somebody. I don't accept money as it is. I can't ask for money.
Okay.
And it's kind of nice, actually. I had to run as DA 3 times, and that was very uncomfortable dealing with people asking for money.
Right.
And I can't as a judge, and I don't. I believe that a person who donates the legal amount or less, you shouldn't have to recuse yourself from the case. That's a freedom of speech issue. You have a right to support whomever you choose, and a donation is a form of support. And it's a First Amendment issue, and I'm certainly not going to be pushed into recuse myself if someone gave me $10,000 and I didn't even know it. It's a legal donation.
Let's. You mentioned your service as DA. I should back up a little bit. Let's talk about your public service career. So after you came back from the military, you ran for the district attorney's office in Rock County and held that for how long, and then became a judge when?
All right. I became a lawyer in '81. I was 34 years old at the time. Took a job with a law firm, the Wickham Law Firm in Janesville. Learned the trial practice. And in 1984, I was asked by the party to run for district attorney, and I did, and won the election, took office in January '85, and I served until, was elected 3 times, but 2 or 3 days into my 3rd term, frankly, I was appointed by Governor Thompson to replace Judge Farnham in Rock County.
1989?
89.
Okay. So
a little better than 4 years as DA.
Okay. Let's ask about some issues in the state budget. Number one, do you think that the Judicial Commission should be put directly under the Supreme Court, Your Honor?
I don't know. I was given I'm a member of the Chief Judges. And
yes, you are.
I've got
for the 5th District, I think?
Yes, 5th Judicial District. And I reviewed the budget cursorily, and we had a meeting of the Chief Judges along with some of the justices of the Supreme Court and discussed the matter. And the opinion was that the budget is not what's going to come out.
Oh, really? It'll be changed?
There are certain parts of it which are going to be changed because the administration admitted that it was an error, portion of it, such as not including court reporters in the mandatory portion of payment, and there's some other changes, but we all know the budgetary process. The governor proposes, the legislature disposes, and after fighting in the argument, we'll have a budget, and may or may not look like it is.
But with his veto power, the governor may get the final determination there.
You're right. You're right.
You getting ready for the show, I found you support the constitutional change on the April 7 ballot.
I do.
And this would elect the justices to elect the Chief Justice. Why is that a good idea?
I believe, frankly, that the democracy is a great idea. It's a great idea. And I think the time has come for us to permit the justices of the Supreme Court to vote for who they wish to represent them to the legislature, to the governor, to the people of Wisconsin, and to the entire judiciary. I think participatory democracy is a great idea. My opponent is taking an opposing position.
Yes, she is.
And that is mainly because she wishes to keep the status quo, and I don't think the status quo is what we really need at this point in time.
Do you think the votes of a Supreme Court justice for who should be the Chief Justice should be made public, Judge?
Good question. I think the discussion among them could be public, much like a campaign, but vote is like I don't want somebody in my voting booth with me on the when I go to the polls on April 7th. I think the vote itself could be a secret vote, and I have no problem with that. But I think that their discussion among themselves as to who should be the Supreme Court justice might be interesting to hear, frankly.
What would be your criteria if you're elected in terms of voting for the next Chief Justice, Your Honor?
Someone who can build bridges. We've got a wide and unhappy divide among the justices. I don't think anybody, unless you've lived in a basement someplace without any public media, has missed over the last 6 or 8 or 10 years the division on the court, which is very public at times. I want somebody who's going to be Chief Justice who's going to be able to build bridges and hammer home the concept that it's great to disagree with each other, but let's not be disagreeable.
How would you come in as a peacemaker if you're elected, Your Honor?
My different roles, 36 years in the military and district attorney and the presiding judge of Rock County. I've had creating a citizens advisory group for a criminal justice advisory group. Mm-hmm. We've had to work with diverse people we normally wouldn't agree with on anything. But you focus them on the goal. How do we improve the system for the citizens of Rock County? Improve it for every citizen. And if you can focus everybody on the goal, and the goal is providing the best justice system for the people of the state of Wisconsin, it's something we all can agree on. Let's start focusing on the things we can agree on instead of focusing on the stuff we disagree on.
You identified yourself as a conservative. Would you then not vote to keep Chief Justice Shirley Abrahamson as a Chief Justice? Would you vote for someone else?
I could vote for someone else. I could vote for her. I haven't made my decision yet.
Okay.
But I want somebody who's going to be a bridge builder, not a bridge burner.
Okay. You said that third-party groups should have a right. It's a free speech issue, correct?
It is, First Amendment.
What they spend, should that be made public, though, in terms of the public dialogue surrounding an election for, like, the Supreme Court, Your Honor? Should it be disclosed?
I don't know. That's something for the legislature to decide.
Okay.
I could live with either way since I can't coordinate with third parties.
Do you need the support of third-party groups to get elected?
I'd love to have support of third-party groups, a lot of third-party groups. But obviously, as you know the system, we can't go out and ask for it. We certainly can't coordinate with them. But it's for them, I think it's as much participatory democracy as me voting in the voting booth. They have a right to support whoever they believe should be on the Supreme Court, or who they believe should be Chief Justice.
Is there any third-party group that you would rather not get involved in this race just because their views are too toxic one way or the other, left or right, sir?
Don't know.
Okay.
I've been so focused on the campaign. I don't know of any group. I'll accept support from groups who believe in the Constitution and believe in the rule of law. That is limiting for some groups, but that's the only limit I have. If you believe in the Constitution of the United States and Constitution of the state of Wisconsin and the rule of law, come aboard.
Another issue being debated in the Capitol is whether there should be a mandatory retirement age of 75. Should there be?
Well,
because if you got elected, it would nip a couple years off your...
It sure would.
Yes, because
make my wife very happy. Make my wife very happy.
Yeah.
I'm sure. But the point is, I had a professor in college who had a sign, my advisor, who had a sign on his door that said, "Vote against all incumbents." And I thought it was a great idea until I ran my second time for DA.
And you were an incumbent.
Yeah, exactly. I don't like anything which prevents the voters or the people of Wisconsin or any jurisdiction to not vote for somebody they think would be appropriate for the job.
Okay.
I mean, if the legislature passes it and they make it a law, well then I'll abide by it. But I don't like the idea of the voters not being able to vote for somebody they think is, the legislature say, is too old, even though they may be pretty sharp still.
You're running for the Supreme Court, which leads the judicial branch of government. Is the legislature beginning to infringe on the separate powers of the judicial branch with some of these initiatives, Your Honor?
Some would say that, and some would also say that the Supreme Court crossed the line on a couple of decisions, ordering the executive branch to do something.
Okay.
In State versus DuBose, in State versus Gerald C.L. Gerald C.L., they ordered the executive branch to at all time videotape juvenile statements, all statements. Now, the test before that was if in fact they didn't like the statement taken or the circumstances taken, they'd suppress it. That'd be the end of it. But in that case, they ordered an executive branch that you're going to do this each and every time. And where does the power of the Supreme Court limited then? Is there any limit to the Supreme Court's power if that's the way they can operate? So it goes both ways. I mean, some people would say the legislature may have overstepped the bounds, and then of course that'll be tested in court. Guess who gets to make that decision?
Yep. Yep. The bench to which you're running.
Who makes the decision, like in re Gerald C.L.? I mean, who makes that decision? Who overturns the Supreme Court of the state of Wisconsin ordering another branch to do something?
One thing that intrigues me about Rock County, in your tenure, you've seen the introduction of drug courts and a veterans court and an OWI. Is there any other county that has all three of those specialized courts, Your Honor?
La Crosse might.
Okay, but
La Crosse might.
The point is, you're maybe one of two counties. Tell me why you believe that there should be these specialized courts and how well they work, sir.
All right. The drug court and we started with the drug court, and it's using the authority of the courts to encourage people to treat and validly treat. And if they don't do it, there's immediate sanctions. And I'm one of the dinosaurs. I didn't like that. I didn't like the use of the court power like that. But then I saw how it worked in Dane County, and I thought it'd have an opportunity to affect lives and lower the crime rate, frankly. Now, we're dealing with the worst of the offenders who are grievously addicted to heroin or substances.
Yes. Addictions.
Yes. And we have changed a bunch of people's lives when they no longer offend, and it's a very low recidivism rate. The same thing occurred when I had the opportunity to start a veterans court.
As a veteran, that was
As a veteran myself.
Very important to you.
It was. And the beauty of that court is that it doesn't cost a dime out of the local tax levy. The VA pays for the important part, or the expensive part, which is the treatment. And they've got a wonderful treatment modality here in Middleton. And I'm very satisfied with the services provided to the veterans, and they changed some lives. And the whole goal of the Veterans Court is to get them in earliest possible time. Earlier you get them into treatment, the quicker they get back to a level of normalcy and can break the addiction that they're involved in. Because usually post-traumatic stress disorder and traumatic brain injury are accompanied by aorta issues, self-medication. But they treat them together. In our drug court, you can't do that. You can't have an addiction and a mental health issue, because they just want to treat with one issue, and it's the best. The system works best that way.
And then talk about the OWI court. Excuse me.
OWI court started in 2013, and that is a different model. Both the other courts are pre-adjudication, in other words, with an agreement holding over the head.
Right.
And
prior to someone being convicted, Your Honor?
Right.
Okay.
And it's pleas held open, and if they successfully graduate, then the contract they've signed is entered into, and the charges are lowered, and it works out very well. OWI, it's post-judgment, and we're using Department of Corrections many times to not only monitor with the alcohol sensors in the skin whether or not they're doing what they're supposed to do and validly treating, and it takes longer, 18 to 24 months in those courts.
Okay. And
it's only been going for 2 years, so it's still a work in progress. We have great hopes.
Do you think these are models for all 72 Wisconsin counties? Should they offer specialized drug vets and OWI courts?
Well, the nice thing about the vets court is we created the model in Rock County. It's a regional court. We take cases from all the surrounding counties. We've taken cases from as far as Outagamie County and Appleton, and he graduated successfully, and as far away as Iowa County. And the system works. We just monitor the treatment. So courts wouldn't, or counties wouldn't have to, wouldn't have to have a veterans court. In fact, VA couldn't support that many courts.
Yeah.
They encouraged regional courts, and that's why it's so important that the model did work for us, that we created. But I do think you can group these cases, and the VA vets court model would be a great model to export to counties like the low-density counties, where you have problems not only with the number of people going through the courts, but also the treatment piece. There's a lot of areas of the county that are undertreated for some of the issues, like aorta issues. So grouping them seems like it might be a good idea if you can work out the transportation issues.
I was also intrigued. Earlier this month, it was announced, a national group announced that Rock County will be one of 6 Wisconsin counties added to the, I want to get the term right, Evidence-Based Decision-Making Initiative. What does that mean, Your Honor?
That means we're focusing in the criminal justice area on evidence-based decision-making. In other words, the evidence that in the studies which have been tested are being used to drive how we treat people, and in the treatment piece, and how we judge which people will be put into treatment. You want to treat the serious ones. You don't want to treat the marginal ones. And you don't want to mix different groups. I mean, that's the things they've learned from the studies. Evidence-based, it really deals with Department of Corrections, deals with the county, yes, DSS, the whole range of services provided to the community through evidence-based practices. And it's very interesting, I gotta tell you. It's a fascinating study and fascinating project that they've done. But what they're doing, we already had 2 counties, Milwaukee and Eau Claire.
Yes, and now you're going to add 8, including Rock.
Right. The 2 systems, as they developed, were developed locally in completely different systems, but are achieving the goals of lowering recidivism and so forth, and getting effective treatment, and focusing on people that you need to treat. 2 different systems, and it's really fascinating to see the different counties working with their own local personalities and their own government and their own various departments, how different they can come up with, but still get the same goals. It's really fascinating.
Is the early results so encouraging that this is another thing that perhaps should be implemented statewide, Judge?
And that's what the goal is to prove the validity of the first 2 counties have been very successful. Now, the 6 counties that have been brought in are of different sizes, large, medium, small.
Okay. So
they want to see if it's exportable and can it be as effective in all size counties.
Okay.
But it takes everybody agreeing that you want to do this.
Okay.
Everybody had to sign on in the county group.
We're almost out of time. Just a couple more questions. I want to give you a chance to respond to the Bradley ad that faults your sentencing, the 1-year sentence of the individual in the child assault case. Do you want to give your response to that ad, please, sir?
Sure. It is. I've been a judge for 26 years and I've sentenced over 30,000 defendants. And the one case was a case in which I based my decision upon the law and upon the facts presented to me, and it was only provided by the district attorney's office and the defendant. The victims did not participate because they chose not to participate, and I really would have liked to have had them there at the time of sentencing, because the sentencing might have been different. But based upon the law and the facts, the defendant had no prior criminal convictions, none whatsoever, had a job, had a high school diploma, and an additional year in the county jail plus 5 years probation, holding 12.5 years in prison over his head, seemed like the good, appropriate decision, along with services. But again, we have to apply State versus Galleon, and my opponent drafted State versus Galleon, which says you've got to first consider probation, then you have to consider the least amount of incarceration necessary to achieve the goals of sentencing, which is punishment, rehabilitation, and safety of the community. And I did that in that case.
Okay. Very complex case, and you got it right, huh?
Very complex case. I got it right with the information I had.
Okay. In the final seconds, I want you to give a closing argument for why voters should come out on April 7th and vote for you, Your Honor.
All right. Voters should vote for me, mainly because I am a 26-year circuit court judge with experience in making complex legal decisions. I am not an activist. I will not overturn the will of the people in favor of my own personal beliefs. Will not legislate from the bench. I believe the rule of law and the Constitution are got to be placed above personal beliefs, individual agendas, or partisan politics. And last, I'll never throw needless roadblocks in the way of our law enforcement officials who daily protect our lives and our families' lives. And with 57 sheriffs and the Milwaukee Police Union endorsing my candidacy, I am law enforcement's choice to be the next Supreme Court Justice.
Rock County Judge James P. Daley, thanks for talking to Wisconsin Eye. And look for our interview with Justice Ann Walsh Bradley. Thank you, sir.
Thank you.
Thank you.